Hello and welcome to the lessons on theories of right. Friends, the exercise and enjoyment of right and enforcement in case of infringement of right are the talk of the time. The concept of the people's basic rights has been given a full and clear account in the form of universal texture in the Charter of Human Rights enacted by the United Nations Organization and the European Convention on Human Rights. Some written constitutions also guarantee a few rights to the people and forbid governmental organs from interfering with the same. For example, the Constitution of India, enacted in Part 3 under the head Fundamental Rights. A question may be posed here as to when and how and in what manner the assertion, conferment and exercise of right came up in the lives of the human being. To this question, the views of the natural law philosophers may be cited. The natural law philosophers, to name a few, are German professor Samuel Pufendorf and the German jurist Christian Wolff. Their view is that men live in a state of absolute liberty and had every right in them without any regulation. Men are strongly motivated by self-love and egotism. Men agree among themselves to abandon the state of nature and unstructured liberty and to enter into a permanent community for the purpose of their natural safety. Thus, all and every rights which everyone possessed without any regulation became regulated by means of administration by the sovereign to whom all have surrendered and dedicated all their rights. Gradually, since the 17th century, a human thinking had erupted into a theory that man has certain essential, basic, natural and inalienable rights or freedom, and it is the function of the state, in order that human liberties may be preserved, human personality developed, and effective social life promoted by giving recognition to these rights. It is imperative to understand what a right is and what is the implication of the term in legal theory. The dictionary meaning of the term theory is a set of properly argued ideas intended to explain facts or events. It is the principles on which a subject of study is based. It may be an opinion or idea, not necessarily based on reasoning. Applying this idea in the theories of rights. Theories of rights means a set of properly argued ideas which are intended to explain facts or events or the principles on which right is based. It is a set of properly argued ideas, probably or possibly true, about, not confirmed or tested in practice. There are two main theories of rights, that is, the will theory and the interest theory. The will theory is also known as natural right theory, and the interest theory is also known as positivist theory, but they are popularly known and pronounced as the will theory and the interest theory. The will theory. According to this theory, right emerges from the human will, that is, a right to be an inherent attribute of human will. The exponents of this theory viewed that subject matter of right is derived from the exercise of human will. Justice Holmes defined legal rights to be a permission to exercise certain natural powers and upon certain conditions to obtain protection, restitution, or compensation by the aid of public force. A strong support to this theory has been given by the doctrines of natural rights. According to J. Locke, the basis of right was will of the individual. Here, will means a trust. Locke believed in inalienable rights. He was influenced by the sin of the society during the reign of the Stuart kings of England, which revealed to him that what a menace the sovereign could be to the individual. So he evolved a theory to protect the individual. His argument was that man lived in a state of nature, but not in a state of anarchy, as Thomas Hobbes has imagined. The state of nature, according to Locke, was a state of liberty, not of license. He found a defect that property was insecure. By property he meant life, liberty, and estate. Every man had property in his person, Locke asserted. Since the source of the value lies in a man's labor, whatever a man hath, mix with his labor, and tie up to it something that is his own, becomes his property. Property was insecure because of certain reasons. For instance, there was no established law. Secondly, there was no impartial judge. And thirdly, there was no natural power to execute natural law. Commensurate with the claim, he stated that to remedy this flaw, man entered into a social contract by which he yielded to the sovereign not all his rights, but only the power to preserve order and to enforce the law of nature. At a time of dedication of their rights, men retain the natural rights to life, liberty, and estate, for they were inalienable rights of men. The purpose of the government was to protect these. It has no other than to preserve the members of the society in their lives, liberties, and possessions. Its function is in the nature of a trust, as Locke pointed out. All this is limited to the public good of the society. so long as the government fulfills this purpose, its laws will be binding. But when it breaks the trust and begins to encroach upon the natural rights, laws lose their validity and the government may be overthrown. The supreme power cannot take away from any man any part of his property against his will and without his consent. If it deals arbitrarily and improperly with the lives and fortunes of the people, it violates the trust relationship under which it holds its power. Thus, the subject matter of right is derived from human will, and the king loses its power when he goes against the will of the people. The historical school of jurisprudence also supports this will theory. Frederick Karl von Savigny, who is also known as the father of the historical school of jurisprudence, is an exponent of will theory of right. He asserted that the nature of any particular system of law was a reflection of the spirit of the people who evolved it. This was later characterized as Volksgist by his most devoted pupil, George Frederick Pachta. He wrote, "Law grows with growth and strengthens with the strength of the people, and finally dies away as the nation loses its nationality." The will theory of right also finds support in the views of Jean-Jacques Rousseau. He firmly believed in the existence of natural rights of the individual, but deserted this classical tradition by seeking the ultimate norm of social life, not in indestructible personal rights, but in the supremacy of a sovereign and collective general will. In civil society, the individual is subject to no other individual, but merely to the general will, volonté generally, that is, the will of the community. Sovereignty to Rousseau meant the exercise of the general will. The sovereign, he argued, being formed wholly of individuals who compose the state, can never have any interests contrary to others. Influence of the will theory. The will theory, as expounded by John Locke, finds its use and influence in the glorious Revolution of 1688 in England. His idea acted as a good guide, resulting into the outbreak of the revolution. James II, the then King of England, introduced absolutism and assumed to himself all the powers and became a despot. At this juncture, the view of John Locke came to light, that is, as long as the king protects the life, liberty and estate of the subjects, his laws are binding. But if the king encroaches upon the liberty of the people, he is fit to be overthrown. In support of will theory, his views was that positive law might be overborne by natural law and sustain the American colonists in successful defiance of the British Parliament in the years 1775 to 1781. In Britain, the Revolution of 1688 was the protest against the abuse of the legislative powers by the monarch, and the revolution of American colonies was a protest against the abuse of the legislative powers by the British Parliament. The theory finds support in the view of the Supreme Court of India in ADM Jabalpur versus S. Shukla, reported in AIR 1976, Supreme Court 1207. The case is popularly known as habeas corpus case. During the proclamation of emergency in the year 1975, the presidential order has suspended the right to move the courts for enforcement of Article 21 of the Constitution relating to life and personal liberty. The Supreme Court observed that suspension of Article 21 did not affect the general rule that the executive could not detain a person otherwise than under a procedure established by law, the interest theory of right. According to this theory, the purpose of law is to protect certain interests and not wills or assertions of individuals. These interests are not created by state, but they exist in the life of the community itself. The state only chooses out of them as to such of the interests as it will protect. Eyring, a German jurist, is the chief exponent of this theory. He defines a legal right as a legally protected interest. According to him, basis of right is interest, not will. Eyring passed the early part of his juristic career as an orthodox member of the German historical school, during which time he intensively studied Roman law and published 4 volumes of his work entitled The Spirit of Roman Law. In the 3rd volume of his work, he concluded that the basis of a right was interest, which led him to consider more closely as to how it dealt with the conflicting interests. His idea came to light in his major work, Purpose of Law, Der Zweck in Recht, which he has translated into English by, under the caption, Law as Means to an End. The dominant notion to be found in the exercise of human will is that of purpose. His view is that causality in the natural world is governed by because. A stone falls because without support it must fall. The stone does not fall in order to fall, but because it must fall, because its support is taken away, whilst the man who acts does so, not because of anything, but in order to attain to something. This purpose is indispensable for the will as the cause is for stone. As there can be no motion of stone without a cause, so can there be no movement of the will without a purpose. He stressed the problem of society is to reconcile selfish with unselfish purposes and to suppress the selfish when they clash with the unselfish aspects. In order to reconcile the individual with society, it is necessary to balance various interests which he grouped into three categories, that is, individual, state, and social. The social activities of the people need to be encouraged, and this is accomplished by means of the principle of levers of social motion. The point which emerges from Eyring's analysis is that laws are only one type of means of achieving an end, that is, social control. His analysis led him to a definition of law in the following terms. Law is the sum of social life in the widest sense of the term as secured by the power of the state through the means of social compulsion. His concern was to examine the origin of laws, not their application. In this sense, law may be bad today and good tomorrow if the social background has shifted in the meantime. Roscoe Pound of Harvard Law School also explained right as an interest. He talked about social engineering to mean to build an efficient structure of the society as possible, which requires the satisfaction of maximum of wants with the minimum of friction and waste, which involve the balancing of competing interests. John Salmon of New Zealand also defined right to be an interest recognized and directed by a rule of right, but he added enforceability to it as a necessary element of right. George W. Patton of Australia defined a legal right in terms of an interest recognized and protected by a legal order. Buckland also defined a legal right to be an interest or an expectation granted by law. I want to conclude my discussion by holding that on a careful analysis of the two theories, it is clear that they do not oppose each other. It may be said that a synthesis of the two theories will give a clear picture of a right is in the legal theory. C.K. Allen attempts to reconcile the two theories by pointing out that the essence of legal right seems to be not legally guaranteed power by itself, nor legally protected interests by itself, but the legally guaranteed power to realize an interest. An interest is a formal expression of the will of an individual or a group of individuals. Thank you very much.